She basically just reiterated the same facts that on the incident, the defendant got upset, then came back with pepper spray and sprayed her in the face. She was able to get solution to flush in the office to flush out her eyes, but she is not currently not on Zoom, but we will have to speak with her. Thank you.
Thank you, Ms. Gant.
Good afternoon, Your Honor. Miss Latonia Sanders is 32 years old. She has been in the Atlanta area for 6 years. She has family here, including a daughter and her father her father passed away 1.5 weeks ago, and the family is in the process of making arrangements, and she is wanting to definitely be a part of that planning process. She also has a daughter who was just released from the hospital last Thursday. She states her daughter was diagnosed with COVID. Your Honor, we are unopposed to the stay away at 2400 Sullivan Road. Ms. Sanders does not want any contact with the complaining witness, Tara Reed. Ms. Sanders completed high school. She also has a technical degree in culinary arts. She is employed at extended stay. She has been in that position for about 1.5 months. However, she is still on probation and she needs to get back to work. She denies the allegations, Your Honor. She states that 3 people were attempting to jump her and that she denies spraying anything. She did not spray any pepper spray on anyone. My client advises me that she has 1 arrest back in 2017 for theft and affray. She states that that was dismissed. That incident involved her sister. I am requesting a signature bond on Ms. Sanders' behalf. I did not hear about any convictions for violence. She's not a danger to the public. She's not at risk of committing any felonies. We did not hear about any FTAs, and primarily I'm requesting this signature bond because of her ties to the community, but she also has some pressing needs around her family, specifically her daughter and her father. Thank you, Your Honor.
All right, it'll be a $3,000 signature bond through the jail. Stay away from the Sullivan Road address. No further contact with Ty Reed, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Sanders.
Thank you, Your Honor.
All right, South Annex, y'all have a good afternoon. I'll see you tomorrow.
Thank you, Your Honor.
Let's see, are we ready in courtroom 2?
Yes, Judge. Good afternoon. It's me again, Sergeant Johnson. I have an announcement, please.
Okay,
I'm working by myself. If everyone can be patient with me today, please, and thank you.
We'll be very patient, Sergeant.
Thank you.
Who do we have?
We have position number 1, Ms. Adams, please.
Good afternoon, Ms. Adams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Is that yes?
Yes, sir.
Okay, thank you, Ms. Adams. You've been charged in case 22 CR 002426A with simple battery and criminal trespass. Is there a history, Mr. Howard?
She got at least 40. She has an open case in the care for disorderly conduct and simple battery against police or law enforcement. That was her last arrest. That was in February out of Doraville. She has history out of Tennessee, violation of probation, filing false report 2012, another violation of probation 2012, 2014 violation of probation, 2014 sale of cocaine. Also has history out of Illinois, 07 trespass conviction, 2008 disorderly conduct conviction, 2008 possession of drug paraphernalia, 2009 criminal damage to property, another 2009 arrest for theft.
Okay, thank you, Mr. Howard.
That's not my name.
Who's representing Ms. Adams?
Hold on, I'll tell you who's representing. My name is not Adams, so sorry, I'd like to tell you.
Your Honor, Ms. Adams is a conflict case.
Oh, Miss Watson.
And I'm sorry, Your Honor,
this would be a breakout case for MH concerns.
Okay.
I have a lawyer somewhere. Miss Watson in the cafe.
It doesn't look like she's on yet, Judge, but it's a conflict case.
Okay.
Ms.
We're
Watson.
gonna need to go. We're gonna have to hold for Miss Watson Cafe courtroom too. So if we can come back to Miss Adams.
Yes, Judge.
Thank you.
Position number 2, Mr. Beasley is next, please. Come on, Mr. Beasley. Thank you.
Your Honor, this is also we're requesting a breakout on this case as well.
Okay, give me all the cases that you're requesting a breakout on today, please.
Yes, it's position 1, 2, and 7.
Okay. So 7 is a medical reset for tomorrow. So let's see. Is this your client, Ms. Gant?
Yes, Your Honor, position 2.
Okay, so good afternoon, Ms. Watson Cafe. How are you?
Good afternoon.
All
Good,
right.
Your
Let's see, Ms. Watson Cafe, they're requesting a breakout room. Your position 1, Ms. Adams, for some concerns that the solicitor's office has. They're also requesting that for position 2, and Ms. Gant, position 2 is your client? I mean, yes, Ms. Gant?
Yes, Your Honor, position 2.
Why don't we all go into a breakout room at one time, if you don't mind, so that we can deal with everything that needs to be taken up in a breakout room, so that we don't delay court. So can we put Ms. Sari, Ms. Watson Cafe, Ms. Gant? I take it that Ms. Weidman's going to want to be in the breakout also.
Sir, may I ask you a question?
Yes, good afternoon, Mr. Beasley. I'm Judge Eric Morrow. You have a right to remain silent. Anything you say can be used against you, sir. Ms. Gant is your attorney, and I will be happy to give you the opportunity to speak with her if you have some questions, okay?
So I'm not going to court today, Mr. Morrow.
Yes, you're in court right now, Mr. Beasley. So I'm about to discuss your case with your lawyer, okay? So if you'll just sit tight for me for a moment, we'll get back with you.
Yes, sir.
Okay, very good. All right, so
Sit
can
right
we,
there, you good.
I thought he should go back. I
You good. You can sit right there.
thought he should go back.
Okay, courtroom 2, we're back with Mr. Beasley. Mr. Beasley, I've had an opportunity to speak with your counsel and with the solicitor regarding this matter. It's going to be a $500 good bond. If you have an active suspension from MARTA, you're going to have to stay away from MARTA if there's an active suspension, and you can have no drugs, alcohol, or weapons while you're out on bond. Okay, sir, good luck to you.
I can't get no signature bond. I got a hold in Lawrenceville, man.
Mr. Beasley remains silent. The judge has ruled. He's aware of your situation.
All right. And who do we have next?
Can you tell me when I'm coming back to court?
Mr. Beasley, I will give you a call, sir.
Yeah, right.
Haven't seen that blue shirt back there for me, B. Can we go back to position number 1, please, Judge?
Okay. And Ms. Adams, I have also had a conversation with your counsel and with the solicitor's office. For your case, it's going to be a $500 good bond on each count, which makes it a $1,000 good bond. No drugs, alcohol, weapons while out on bond, a mental health evaluation, no further contact with Bernita or Tony Murray, and stay away from 175 Pekin Avenue.
I don't know them, and my name is not Kelly Adams. It hasn't been that in a minute. It's Cecilia K now. I
Okay.
changed my name and married someone else.
All right, thank you, ma'am. Your attorney will discuss that with you. Thank you. Who do we have next? Doing all right today, Ms. Franklin Redden?
I am, thank you for asking.
Good, I'm doing fine, thank you.
Had a good weekend?
Too short.
It's too short.
So whenever you get situated, courtroom 2, we're ready to proceed.
I know, please just be patient with me. I'm trying to get these 2 back to medical. If you all could just be patient with me, okay? Thank you.
You're fine.
That's Sergeant Johnson. Thank you.
Position number 9 is next, Judge, please.
Okay,
Thank you.
you're welcome. Good afternoon. Ms. McLean, I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 002445E with no insurance. Is there a history, Mr. Howard?
Third arrest, 2015 forgery in the second. She got first offender for that. 2013 financial transaction card theft and fraud, first offender. That's all I have. State might have something else.
Mr. Segura?
Okay, for the facts, the date occurred on April the 24th, 2022 at the location of Spring Street and Amsterdam Place, Northwest Atlanta. In this case, the police activated emergency lines on a traffic stop on a defendant's vehicle at the incident location. And when the police investigated the defendant, they found out that the vehicle registration was valid, but the vehicle insurance was not. And as for the defendant had been arrested because she had a prior FTA on driving without vehicle insurance as well. Because of this, we're asking for a $2,000 signature bond alcohol, drugs, and weapons, and no driving without valid insurance. They increased the amount of extrinsic bonds mostly because of the FTA, and so we kind of rolled you to do this again.
All right, who's representing Ms. McLean? Ms. Gant, do we know who's representing Ms. McLean?
I believe that is J. Kim, Your Honor.
I apologize. I'm here. I'm trying to set up here. Sorry about that.
Okay, I take it you don't oppose a signature bond, Ms. Kim?
No, I don't, Your Honor.
Okay, $2,000 signature bond through the jail. And no driving a vehicle without valid insurance.
No problem, Your Honor.
All right, good luck to you, Ms. McLean.
Thank you, Your Honor.
Who do we have next?
Judge, can you give me one moment, please? I do apologize.
Oh, no, that's fine. Yeah, just let us know when you're ready.
I do apologize, Judge.
That's fine.
Can we go back to position number 9? I just need to hear the bond amount, please.
Okay, the bond is a $2,000 signature bond through the jail.
Okay, thank you, Judge. And then we go to position number 4, Mr. Cross. Come on, Mr. Cross, have a seat right here for me. Thank you.
You're welcome.
Have a seat. Thank you.
Good afternoon, Mr. Cross. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Cross, you've been charged in case 22 CR 0024428A with obtaining unlawful entry into MARTA and possession and use of drug-related objects. Is there a history, Mr. Howard?
54 total. On probation and card, theft by receiving, possession of cocaine. Last arrest was back in March 31st, probation violation. March 29th, trespass on MARTA. That's open in state court, 22 CR 001-805A. I counted about 22 parole violations in this issue. That's enough?
Yes, thank you. Ms. Sari?
Yes, Your Honor. In this case, officers were dispatched to the MARTA at 30 Alabama Street in Atlanta regarding a criminal trespass. The defendant entered into the MARTA station through the emergency gate without paying the required fee. And upon search incident to the arrest, the defendant was found in possession of 2 clear glass pipes used for smoking dangerous drugs. Your Honor, we've heard from pretrial regarding this defendant's history. He does have multiple arrests for possession of drug-related objects, which resulted in a guilty conviction. He does have a 2019 possession of firearm guilty conviction. And in that open murder case, he was given a $2,000 signature bond through the jail. And here he is today, along with a probation violation from March 31st of this year. The state's recommendation is a $3,000 surety bond. That's $1,500 on each charge, with conditions of staying away from all MARTA locations and no drugs, alcohol, or weapons while on bond. Nothing further.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. James Cross is 62 years old. He has been in the Atlanta, Georgia area for 12 years. He has family here. He also is a proud father of 8 children. 7 of his children are alive. Your Honor, we are unopposed to the stay away at the 5 Points MARTA location, the incident location. Mr. Cross he obtained a GED. He is retired and has been so since the beginning of this year. He was a commercial truck driver. He denies the allegations, and I am requesting a signature bond on Mr. Cross's behalf. He does not have the means to pay bond. He does not have anyone to call. These are non-violent offenses. He's presumed innocent in this case as well as any other open cases, and he informs me that the case in Cobb County is not open. He states that I will back up and state that he does not believe that the case is closed, but I would submit to Your Honor that if in fact it's open, he is presumed innocent in that matter. And for these reasons, I am requesting a signature bond or the lowest bond possible, as he does not have the means to pay any bond. And the stay away, we would just ask that that be limited to the 5 Points MARTA location. Thank you.
And we're asking for a stay away from all MARTA locations. He has an open case with MARTA, and he was given a stay away from there. And now he's come to a different location and has picked up another case. So, Your Honor, the state feels that this defendant would need to stay away from all MARTA locations until the cases have been resolved. Nothing further.
Does MARTA have an active suspension?
I believe so, Your Honor.
Okay. So it's going to be a $250 good bond for each charge, which makes it a $500 good bond total. No drugs, alcohol, weapons while out on bond, and to abide by any active suspensions that MARTA has in place. Good luck to you, Mr. Cross.
Thank you.
Thank you.
I have position number 5 next, please, Judge.
Okay. Good afternoon, Mr. Garland. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are holding by video to help you better the virus. Do you agree to have your case heard by video?
Yeah.
Thank you. Mr. Garland, you've been charged in case 22CR002448B with possession and use of drug-related objects and criminal trespass. Is there a history, Mr. Howard?
86. Last arrest was last month. Clayton County criminal trespass conviction. January, Clayton County trespass conviction. April 2021, possession of drug-related objects. Public indecency arrest. It's kind of extensive. So, anything in particular you looking for?
Anything in the last 10 years?
Yeah, it's a lot in the last 10. All right, so
28.
Hmm?
Start from 2022 and go backwards. Can you do that?
That's what I'm doing.
Okay.
2018 probation violation, possession of cocaine. 2016 disorderly conduct conviction. 2016 sale of possession of a controlled substance. I don't have a disposition for that one. 2016 probation violation, possession of cocaine, possession of drug-related objects. 2015 possession of cocaine, possession of drug-related objects. The drug-related objects was a conviction. 2015 misdemeanor possession of marijuana, 2014 trespass, 2013 trespass, another 2013 trespass conviction, another 2013 trespass, and another one.
Okay, that's good, Mr. Howard. Thank you. Ms. Sari?
Yes, Your Honor. In this case, officers responded to the incident location of Marta at 30 Alabama Street in Atlanta regarding a criminal trespass. They were advised by multiple patrons that the defendant was inside of the MARTA station smoking and drinking. When officers arrived, they did in fact see the defendant with an open beer can in his hand, and he also had a clear glass pipe in his possession. When officers told the defendant to leave, he instead boarded the train. Officers yelled at him again to get off the train, and he refused. He was then arrested. Your Honor, as we've heard from pretrial, this defendant does have a significant history. He has 86 cycles. In 2020 alone, he was arrested 6 times for possession of a drug-related object, and 2 times in 2021 for possession of drug-related objects. I'm not able to find the dispositions in Odyssey. However, he does have a 2015 possession of cocaine and possession of drug-related object that resulted in a guilty conviction, and 2 criminal trespass cases that resulted in guilty convictions. The state's recommendation due to this defendant's history is a $3,000 surety bond. That's $1,000 on each charge, with conditions of staying away from the incident location and no drugs, alcohol, or weapons while on bond. Nothing further.
Ms. Kim?
Yes, Your Honor, Mr. Garland is 50 years old, and he has been homeless for a while. And he has been here in Atlanta, Georgia all his life. He has no family. And I am requesting for behavioral health evaluation tests, since he is claiming that he has been a preacher ever since he was a kid. So we would like to request for that. And he has no means to pay for $3,000 surety bond. So we would like to request for $500 surety bond, Your Honor. Thank you.
Okay, it'll be 250 good bond per charge, $500 good bond, social worker visit for a behavioral health evaluation, abide by any active MARTA stayaways, and no drugs, alcohol, or weapons while out on bond.
Thank you.
Good luck to you, Mr. Garland.
I'm sorry, what was the bond amount? $500 good bond, you said?
Yes, 250 per charge.
That would be a $750 good bond. Charges.
Oh, I only have 2 charges.
Me too.
We added the open container.
I don't have that.
But I'm sorry, I only have, do you have 3 charges, courtroom 2?
I only have 2 charges.
Okay. So, Ms. Kim, do you have 3 charges?
No, Your Honor, I only have 2.
Okay, so when did you add the charge, Ms. Sari?
This morning, Your Honor. But we can, if we can just go ahead and we'll amend it to add the charge.
Well, I need to know, because I don't, if this man can make bond, I don't want him sitting in jail. So
it was added this morning.
all right, so just to make sure,
So, Judge, I don't.
I'm sorry, Your Honor. It was not added this morning, so we'll just go forward with how it is today.
Thank you, Your
Okay.
Honor.
All right, so he has 2 charges. He's getting a $250 good bond on each charge.
Yes, Your Honor.
All right, good luck to you, Mr. Garland.
Just stand right here by the chair. Next, we have position 3, Ms. Carol.
Good afternoon, Ms. Carol. Would you like to have a seat, or can you sit down?
No, she's
No.
not able to.
Okay, that's fine. Good afternoon, Ms. Carroll. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Carroll, you've been charged in case 22 CR 0022441F with criminal trespass and simple battery. Is there a history, Mr. Howard?
The third arrest. Last was 2012 shoplifting conviction. Another 2012 shoplifting conviction. That's it.
All right. Ms. Sari?
Yes, Your Honor. In this case, officers responded to 320 Fairburn Road in Atlanta regarding a domestic dispute. One of the victims in this case is Lakita Smith, Lakita Smith, common spelling. She explained to the officers that the defendant had been messaging the other victim in this case, who was Kee Avery. When the victim Avery arrived to the defendant's door, the defendant asked for a folder that contained important documents that belonged to her. And when the victim, Ms. Smith, stated that Mr. Avery did not have them, the defendant then pushed Ms. Smith and went outside with a hammer. The defendant then proceeded to smash the front window of the victim Avery's vehicle. When officers spoke with the victim, with the defendant, she admitted to damaging the window by swinging on it. And when the officers spoke with the victim Avery, he was not on the scene at the time, but the officers were able to get his number from the other victim. Mr. Avery stated that he was at the apartment to drop off documents when the defendant asked for a folder. When the victim ignored the defendant's question, she went inside to retrieve a hammer and proceeded to smash his window. And the victim, Mr. Avery, he did record this incident on his phone. He also told officers there's a history of violence between the two and that they do have 3 children together. Your Honor, the victim, Mr. Avery, in this case, he was actually a defendant in a case where he pled guilty back in May of 2021 to simple battery family violence, criminal trespass family violence, and the battery family violence was null prost. So the victim in that case was the defendant today. So they do have a history of violence. So for that reason, this defendant does present a risk of intimidating the witness, as well as her other 2 cycles, she present a risk of reoffending. The state's recommendation is a $3,000 surety bond. That's $1,500 on each charge, with conditions of no contact with the victims, third-party transfer of any minor children, 1-day anger awareness, and the state is not asking for a stay away, as the warrant indicates that this incident did happen on the defendant's property. Nothing further.
Ms. Watson Cafe?
Yes. First, I do want to address 2 things. They do not have a history of violence. The alleged Mr. Avery has a history of violence. As pretrial has indicated, her 2 priors were nonviolent priors. Ms. Carroll is a lifelong resident of Georgia. As Ms. Story correctly stated, this is her residence. She vehemently denies the allegations as stated. She is currently the mother to 6 children, 5 of which reside with her and Mr. Avery at the house. She is not currently requesting a no contact order, but so we would be asking for a no violent contact if Your Honor requires some type of order to that account. Again, she has very strong ties here. She is gainfully employed at the airport, where she makes $15 an hour. Miss Carroll, as she stands here today, is currently suffering from a miscarriage, Your Honor. And so we are asking for a signature bond to allow her to leave the jail and get immediate medical care for what she's literally experiencing right now. It's the reason why she can't sit right now, from my understanding. She, again, she's gainfully employed. She has ties. There's no reason to believe that she would reoffend. She does not have a violent history. And just based on her income and the number of dependents that she has, we would ask that Your Honor take that into consideration and the immediate need for real medical care in granting hopefully a signature bond. If Your Honor is not amendable to a signature bond under these circumstances, we would ask that the bond be no more than $500, again, to allow her to immediately leave here and go to the hospital to address what's going on with her today.
Okay, I'm going to give her a signature bond, Ms. Watson Cafe. I'm more concerned about the
Yana.
Mr. Avery and Lakita Smith.
And
I see Mr. Avery on the line. Mr. Avery, if you would like to address the court, now is your opportunity to do so. I'll need to swear you in and you'll have to unmute yourself. Would you like to address the court?
Yes.
Okay, you're gonna have to stop walking for me and get yourself situated so you can speak to me.
Yes.
Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, sir. What would you like to tell the court?
This is our first time going through this, with her. So, she just has like we just had a miscarriage with twins. So that's where, she's more depressed about that.
Okay. And you live in the household?
Yes.
And you're not afraid of her?
No.
All right. Thank you, Mr. Avery. So again, it's going to be a $1,000 signature bond for each charge, making it for a $2,000 signature bond through the jail. No further violent contact with Mr. Avery or Ms. Smith, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Carroll.
Thank you, Your Honor.
Thank you.
May I be excused? That's all I have on the calendar.
Yes, have a good afternoon. We appreciate it.
Thank you, Your Honor.
Next, we have position 4, Mr. Cross. Cross already.
Your Honor,
I'm sorry, position 10, Mr. Saheed.
Your Honor.
Yes, Ms. Gant.
Mr. Saheed is my client. However, I have a question regarding Mitchell. Have we heard Mitchell? That is a conflict case as well. I'm not sure of the position.
He was transferred to felony, Ms. Gant.
Transferred. Okay, thank you.
Yeah, you're welcome.
Okay. And I'm sorry, this is Mr. Shaheed. Is that right?
Yes, Your Honor.
Okay, all right. I just want to make sure. Thank you. Good afternoon, Mr. Shaheed. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Shaheed, you've been charged in case 22 CR 0024446B with simple battery family violence. Is there a history, Mr. Howard?
I got this is second arrest, 2019 battery DV, Cruiton the third, 19 CR 010271B. State, do you have anything additional?
Not additional, no.
Was that a conviction or?
It appears to be open.
Open? Okay.
Yeah, I wasn't sure.
Thank you, Mr. Howard. Mr. Segura?
The incident date is June the 5th, 2021, at the incident location at 3097 Maple Drive, Atlanta. In this incident, the defendant got into a verbal argument with his ex-living girlfriend, a Miss Sikumbuzuro Moyo. The first name is spelled Sikhumbuzzo, and the last name Moyo, spelled Moyo. In this case, the defendant struck her in the face with a closed fist. But the state is recommending a $3,000 surety bond, alcohol, drugs, and weapons, one-day anger awareness, and stay away from the incident location of 3097 Maple Drive, Atlanta, and no further contact with Ms. Moyo. We're making this recommendation based on the facts and also because of what we find in his criminal record. First is that open cases Fitzgerald has noted, which is 19 CR 010271B, which even though it's not the same victim, it still was at a time of a female relation who lived in the same household and which he done in front of children, and that the dates only 2 years apart. And also, we actually spoke with Ms. Moyo earlier today. She stated that both of them lived together for almost a year and she had not contacted him since the incident. But she did confirm, in her own words, that he did in fact punch her in the face and then ran away. And as we know, she's actually on Zoom right now if you would like to hear from her. But due to the violence, and especially considering he's not new to commit violence of a domestic nature of a female resident, this is our basis. Thank you.
Okay, so, Ms. Gant?
Thank you, Your Honor. Mr. Abiyan Sahid is 40 years old. He has been in the Atlanta, Georgia area for 10 years. He has 3 children, ages 3, 2, and 9 months. He informs me that he is the primary caretaker and that he is not receiving any child support. We are unopposed to the stay away at 3097 Maple Drive. Mr. Sahid also informs me that he does not want any contact with Ms. Moyo, the complaining witness. Mr. Sahid completed high school. He also received a certification from ITT Tech in electronic engineering. Your Honor, he isn't unemployed and has been since 2019. He tries to, since January, he tries to sell health and beauty products, but that has been not profitable, Your Honor. He denies the allegations. He states that there was a restraining order and that he had not seen that person, Ms. Moyo, on June 5th, the date of this incident. He just did not have it. He states that she has a habit of making false allegations against him. He states that he was unaware of this warrant. My client has an open case, Your Honor. He is presumed innocent in that case, in this case as well. And given that he has no convictions and he's 40 years old, which speaks to his past history, I would ask for a signature bond on Mr. Sahid's behalf. And if Your Honor determines that he is ineligible, then a bond of no more than $500, as he states that he does not have anyone to call. However, on his person or his property at Fulton County, he does have $500 and would be able to bond out that way. Thank you, Your Honor.
Ms. Moyo, I see you on the line. If you would like to address the court, now is your opportunity to do so. If you like to, can you raise your right hand?
Yes.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Thank you, ma'am. What would you like to tell the court?
Yes, this incident actually occurred at the Cyan on Peachtree, and he did assault me by punching me, and he ran off after. And I believe on the same passage, there's cameras there, so there should be a footage of him assaulting me.
Okay, and do you know Mr. Sahid?
Yes, I do.
Okay. Anything further, ma'am?
No, that will.
All right, thank you. Mr. Segura, Ms. Gant, anything further?
I wanted to emphasize that due to these open cases and the fact that he actually committed a domestic violence incident twice already within the span of 2 years, we would like to emphasize the need of a surety bond.
Okay, Ms. Gant?
Nothing further, Your Honor. Thank you.
All right, it's going to be $1,000 good bond, no further contact with Ms. Moyo, stay away from the Maple Drive address, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Sahid.
And can you also add no further contact, or was that already said?
Yes, I said no further contact with Ms. Moyo and a stay away.
Thank you.
Ms. Gank, can you call the courtroom 2 for me, please?
Yes, I will. Thank you.
Judge, next I have position number 15, please.
Okay.
Mr. Weaver. Thank you. Weaver.
Good afternoon, Mr. Weaver. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Weaver, you've been charged in case 22 CR 002453A with battery family violence. Is there a history, Mr. Howard?
First arrest.
Good afternoon, Ms. Harmon.
Good afternoon, Judge Morrow. As far as what I reviewed, the offense date in this case is 4/24/2022 at the location of 33 11th Street in Atlanta. And it appears that it's limited facts in this case. We only have the warrant that the parties were living together at the incident location. And the warrant indicates that the defendant pushed the victim in this case, Anna Lindgren, and I'll spell her last name for the record, Lindgren. He pushed her onto the bed and she sustained a bloody nose as a visible injury. We believe that the defendant presents a danger to this victim, and even though there are limited facts, it is concerning that the injury that he inflicted upon the victim caused a visible injury. And I will acknowledge, Your Honor, that these are cross defendants. Ms. Lindgren was arrested, I believe, this morning. In light of the limited history, but taking into consideration the danger he presents to the victim, our recommendation in this case is a $3,000 surety bond, no further contact with the victim, stay away from the incident location, 1-day anger awareness course, no alcohol, drugs, or weapons in this case. Thank you.
Okay, Ms. Kim.
Yes, Mr. Jacob Weaver. He is 42 years old and he has been here in Georgia for 22 years. He and his cross-defendant are married ever since December 2021. And of course, he was not the primary aggressor at this point in this case. And right now, he has all kinds of business in his house, lots of computers and stuff like that. And he is the primary owner of the house, 33 11th Street. So we would like to oppose against stay away from that incident location, since he is the one who owns the house and he is the one who has a lot of equipments to operate his two business in that location. And this is his first offense, so we would like to request for signature bond, Your Honor. He is very qualified and recommended as well. Thank you.
Ms. Harmon, were they arrested at the same time, or because I don't see Ms. Lindgren on this calendar? Was she arrested at a later time?
I believe she was arrested this morning, so I think she will be on the first appearance calendar tomorrow. I think she did not make the cutoff. And I understand it's limited information here, Your Honor. However, what I do know is that she sustained a visible injury, like I said, a bloody nose, which is concerning. So I don't think that the defendant should be allowed to go back to that house, especially if he's going to inflict injuries like this upon his wife. So that's our concern. So we would insist upon the stay away.
What was she arrested for?
I apologize, Your Honor. If you give me one moment. I was trying to look for her earlier.
Okay, that's fine, Ms. Harmon. I will address her tomorrow. As far as Mr. Weaver goes, he doesn't have a history whatsoever, so it's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Anna Lindgren, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
All right, good luck to you, Mr. Weaver.
Thank you, Your Honor.
Judge, I'm sorry, how much was the bond again, please?
$3,000 signature bond through pretrial.
Thank you. Position number 16, Mr. William. Is next, please?
Okay.
Not you, Williams. I have two.
Is this Mr. Denzel Williams?
Yes, Judge, this is Mr. Denzel Williams.
Okay, good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. How you doing today, Your Honor?
I'm well, Mr. Williams. Thank you for asking. Let's see, you've been charged in case 22 CR 002454G with simple battery family violence. Is there a history, Mr. Howard?
Yes, this is fifth arrest. Last was 2017 for disorderly conduct. Hold on. Yeah, he got a suspended sentence for that. It was a trespass with that arrest. That was a conviction. He got 12 months probation. 2015 simple battery. It was NOD. 2014 disorderly conduct conviction. And a 2010 battery, simple battery. They were dismissed.
All right. Ms. Harmon?
Yes, Your Honor. This incident took place on April 23rd, 2022 at 3072 Washington Road in East Point, Georgia. The officers responded to the incident location regarding a domestic dispute. The parties, the victim in this case is Latoya Richardson. That's Latoia, last name Richardson, common spelling, who is the defendant's mother. So they came to the incident location. They were arguing about the purchase of some food items and who was supposed to cook those items. And when Ms. Richardson walked into the kitchen, the defendant pushed her onto the floor. And as she went down to the floor, her shirt ripped in the process. I believe, Your Honor, that this defendant presents a risk of reoffending and intimidation to this victim. As it relates to the simple battery that was NOD'd in 2015, that was the same victim. That was his mother again. And he was arrested on August 2nd, 2015. He pushed her on the floor and put her in a headlock. She told prosecutors at that time, the same thing she told us this time, is that she wants him to get out of jail and that she didn't want to prosecute the case.
I'm not sure I understand.
I'm sorry, I apologize, that's my watch. So this is a concern of the state's, Your Honor, because it's the same conduct, almost identically, with the same victim, and the parties do live together. And so for that reason, Your Honor, we are recommending a $2,500 surety bond, no further contact with the victim, stay away from the incident location, a one-day anger awareness, no alcohol, drugs, or weapons. And I don't believe that she's on the Zoom because she has to work, but she shared, the victim, she shared with our office that she didn't want to prosecute like she told us the last time in 2015, but here we are again with the same, almost identical incident details. So I don't think that, I think we have to take this seriously, and I think we have to, we're going to request a surety bond for those reasons because it's a repeat incident. Thank you.
Thank you, Ms. Harmon. Ms. Kim?
Yes, Mr. Denzel Williams is 29 years old, and I do understand. I want to emphasize that 2015 incident was NOD, and also ever since 2019, he became disabled. He has a serious illness with his hip and knee and back, so he has a hard time moving around, and he does not have a physical position to attack somebody at this point. So there's a misunderstanding about what happened with Miss Latoya and my client, Mr. Denzel Williams. And he has been here in Georgia for the last 13 years. He has all his families here. He's not a flight risk, and he does not have a job because of his disability, and we would like you to consider that part, Your Honor. He does not oppose to stay away or no further contact, and yet he would like to have a no further violent contact because he loves his mom and his mom loves him as well. they take care of each other. They also have a baby sister that they take care of together. So it is very important for them to have no further violent contact. We would like to request for signature bond since he is qualified. There was no convicted violence conviction at all in his history. So we would like to request for signature bond, Your Honor. Thank you.
And Your Honor, I just would like to reiterate, even though Ms. Richardson could not be here, she did state to our victim witness advocate that the defendant did in fact push her, disability or not. So she does state that this incident did happen and he did have the capability to push her over while she was in the kitchen. And again, I wasn't suggesting that it was a conviction. I was just saying it was a repeat incident with very similar facts against the same victim. And I would ask Your Honor to take that into consideration when you make your ruling.
Okay.
It was 7 years ago, Your Honor.
It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Ms. Richardson, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Ms. Williams.
Judge, I told Ms. Gant that position number 6, Mr. Jackson, was gonna be reset for medical, but he was able to come down to get interviewed for court. So can we go to position number 6, please? Come on, Ms. Jackson, if I can get you back to medical. Sit right here. Thank you.
Good afternoon, Mr. Jackman. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Sir.
Thank you. Mr. Jackman, you've been charged in case 22 CR 002443A with battery family violence. Is there a history, Mr. Howard?
Sure, huh? I'm looking for it. Oh yeah, this is first. He lives in Tennessee.
All right, Mr. Segura.
The incident occurred on April the 23rd, 2022 at the incident location of 10975 Georgia Lane, Alpharetta. As the warrant says, the victim is Sheila Jackman. Sheila spelled S-H-E-I-L-A. Jackman, common spelling. She is the ex-wife of the defendant, and they both have 2 kids. As was stated in the warrant, both the defendant and Ms. Jackman was arguing, and at the time, their juvenile son threw a water bottle at the defendant, making contact. But in retaliation, the defendant threw the water bottle back, intended to hit his son, but instead ended up hitting Ms. Jackson's face, which resulted in having visible marks and bleeding from her nose. We are recommending a $4,000 surety bond, no alcohol, drugs, and weapons, 1-day anger awareness, a stay away for the incident location at 10975 Georgia Lane, Alpharetta, and no further contact with Sheila Jackman and both the children except to a third party. Even though this is first arrest, we're deeply concerned because the victim in this case is an ex-wife and all connected by having 2 children. And we're deeply concerned at possible the offensive violence because all this started with the defendant's own young juvenile son throwing the water bottle, in which based on warrant, the defendant stated he threw the water bottle back in retaliation to his own juvenile son, intending to hit him, but instead hitting Ms. Jackman. Because of this, we're deeply concerned by the safety of both the children and Ms. Jackman. And as such, we feel like a surety bond is necessary. Thank you, Your Honor.
Ms. Gant.
Thank you, Your Honor. Mr. Colin Jackman is 47 years old. He is a resident of Tennessee. He informs me that he is in Atlanta because he met his ex-wife, the complaining witness, Ms. Sheila Jackman, so that he could see his children. Mr. Jackman completed high school. He is unemployed at this time, Your Honor, and has been so for the past 6 weeks, Your Honor. He denies the allegations. He denies that he was throwing a bottle of water at his son. He denies that he was throwing a bottle of water at his wife. This was an accident, Your Honor. My client does not have any violent convictions or any history that we've heard of. So I am requesting a signature bond on his behalf, Your Honor. He does not want any contact with Ms. Jackman. The incident location is a hotel. He has no need to, well, let me clarify. Mr. Jackman, do you have any belongings at that location, at that hotel location?
You're on mute, courtroom two.
Mr. Jackman.
You're unmuting.
Mr. Jackman, may you clarify whether or not you still have any belongings at the hotel?
My car is there just with all my belongings in the trunk.
Okay, thank you. So, Your Honor, I would request a one-time law enforcement escort so that he can retrieve his personal belongings there, and a third-party transfer for the children, Your Honor.
Okay, it's going to be a $5,000 signature bond through the jail. No further contact with Ms. Jackman. Stay away from the 10975 Georgia Lane address. He can go back to that address on one occasion with the escort of law enforcement to retrieve any belongings that he might have there. As far as contact with the children, there can be third-party contact. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Jackman.
Thank you, sir.
Thank you, Your Honor.
Position 8, Mr. Johnson.
Good afternoon, Mr. Johnson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir, and God bless you.
Thank you. You also, Mr. Johnson. You've been charged in case 22 CR 002444J with criminal trespass and public drunk. Is there a history, Mr. Howard?
Johnson, yeah, he got 130. He got 1 out of Virginia, 36 out of Tennessee, 50 out of California, 32 out of Florida, and 10 out of Georgia.
Want to give me the last 10 years?
Ooh, I can try. Last arrest in Georgia, 2014, Cobb County, trespass. Felony terrorist threats, unlawful to obstruct, resist, impede, or interfere with person enforcing littering laws. That charge was not prosecuted, but the trespass and terrorist threats was a conviction. 2013 public indecency charge. Before that was an 03 arrest.
Can I say something, Your Honor?
Mr. Johnson, you have a right to remain silent. Anything you say can be used against you. Let Ms. Gant speak for you, okay?
Last arrest in Tennessee was 2010, public intoxication, disorderly conduct. Go to Florida. Last arrest in Florida was 2012, trespass.
All right, thank you, Mr. Howard. Mr. Segura?
Sentencing called on April the 23rd, 2022 at the restaurant called Mamma Mia's, which is at 78 Broad Street, Atlanta. In this case, the defendant was awfully violated a criminal trespass warning issued on April the 1st by the Mamma Mia's restaurant, which is a business connected to the Georgia State University academic building. And this one, it was initially issued on April the 1st and will be active until April the 5th, 2024. That's for the criminal trespass. As for public drunk, when police arrived at the Mamma Mia's, which is in that academic building, the police noted that the defendant had slow speech, was unable to stand, and had difficulty walking and smelled of alcohol. We're recommending a $3,000 surety bond, $1,000 for the criminal trespass, and $2,000 for the public drunk, no alcohol, drugs, and weapons. a stay away from Georgia State University at the particular location of 78 Bard Street, Atlanta. Foundation based on these facts, first because we are really concerned that he will reoffend. Based on his really long criminal history, I'll point out several relevant incidents. In 2022 in Tennessee, he was arrested for public intoxication and also for public intoxication 2016, 2017, 2018, 2008, and 2009 with public disorder. And 2010 was also the same thing, public intoxication and criminal trespass. In his Florida case, 2001, he had DUI, and 2010, public intoxication with disorderly conduct. And same thing again in 2011, which also included a criminal trespass. In Florida as well, in 2012 was again a criminal trespass twice in 2012 with public intoxication, and also again criminal trespass 2013. We were extremely concerned that he will reoffend and commit this combination out of criminal trespass and public drunk in the same area. And also we have to point out he actually has an open case with Georgia State in 2013 for public drunk again. Because of this, we feel like a surety bond is very necessary. Thank you.
Can I say something now, Your Honor?
Okay, hold on. Ms. Gant, do you want to instruct your client?
Mr. Johnson, I advise you not to speak at all. I will represent you.
Yes, ma'am.
Thank you.
Go ahead, Ms. Gant.
Thank you, Your Honor. Mr. Johnny Johnson is 62 years old. Mr. Johnson has been in Georgia for 10 years. He is a resident of Clarkston, Georgia. He has family here, and that would be a niece in Lawrenceville, Georgia. We are unopposed to the stay away at 78 Broad Street. Mr. Johnson denies these allegations. He was unaware of a stay away order there. So we are unopposed to a stay away just at that location, but not from Georgia State University campuses. We do not want to put Mr. Johnson at risk of violating any bond conditions. Mr. Johnson completed high school, and soon after graduating from high school, he enlisted in the Marine Corps from 1977 to 1981. Your Honor, he is unemployed at this time. And although I acknowledge my client's history, he has a social worker and he has taken great strides to turn his situation around. He does have a social worker. He has a job that is lined up. He is supposed to start that job in about 2 weeks, and the VA actually he's getting this job through a VA program called CWT, and the VA has also provided some housing, as homelessness has been in his history. So he doesn't have anyone to call to help him with bond, Your Honor. These are nonviolent offenses, and I would ask that you consider giving Mr. Johnson a signature bond so that he may continue to be a productive member of society, so that he can get out to start his job in 2 weeks, and also to secure his apartment that the VA helped him to get. Thank you, Your Honor.
All right, it's going to be $1,000 signature bond through the jail on each count, which makes it a total of a $2,000 signature bond through the jail. Stay away from Mama Mia's at 78 Broad Street. No drugs, alcohol, or weapons while out on bond. I'm going to let you out, Mr. Johnson, but you're going to have to make sure to return for your next court date. You understand?
I'd like to say, God bless you, Your Honor. Sorry for the trouble.
All right, good luck to you, sir.
Position 12, Mr. Scott.
Thank you, Your Honor.
You're welcome. So I think that Mr. Scott is position 12 and position 13. Good afternoon, Mr. Scott. I'm Judge Eric Murray. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good afternoon, Judge.
Thank you. Mr. Scott, you've been charged in case 22 CR 002449G with battery family violence, and in case 22 CR 002450G with simple battery family violence. Is there a history, Mr. Howard?
Got history out of Florida. Got an 04 carjacking with a firearm conviction. 2006 fugitive from justice hold. It's a '06 conviction for robbery. It says solicit to commit armed robbery. That's all I have.
All right, Ms. Harmon?
Yes, Your Honor. This first incident occurred on March, well, the first case you called occurred on March 20th, 2022 at the location of 42 Rawon Street, RAWON Street. The officers were dispatched to the incident location regarding a fight in progress. It's our understanding that the parties were living together at the incident location. The victim in this case, whose name is Tiara Clark, it's TEAERRA, last name Clark, common spelling. They were involved in a verbal altercation. It escalated and the defendant snatched the phone out of her hand. When she attempted to get the phone back, the defendant hit her in the face. She further indicated to officers that the defendant put her in a chokehold. There was visible bruising to her face and scratches around above her right breast. And she also sustained a busted lip. Her 1-year-old daughter was present during the incident. She also told officers at that time when they were on site that she had called the police previously for similar incidents. As you can see, Your Honor, she is on the Zoom and our office did reach out to her. She told our office that they have been living together, her and the defendant, for 5 years and have a child. She said that this was the first time that the defendant has hit her, but she told officers something totally different. And she also indicated that she didn't need any medical attention. In light of the history that pretrial gave, in light of the fact that the next case is another incident involving the same victim, involving domestic violence, the next case on our calendar, in light of the fact that both attacks are occurring in the presence of children, our recommendation on this case is a $5,000 surety bond, no further contact with the victim, stay away from the incident location, a third-party transfer for children, 1-day anger awareness class, no alcohol, drugs, or weapons. And that's the 2022 case.
Okay, if you'll go on to the next case, please.
Give you the facts for that one too?
Yes, please.
Okay, sure. So on July 13th, 2021, the police were called to the couple's address. They were involved in a verbal altercation, which of course escalated. And in that incident, the defendant punched Ms. Clark in her face with a closed fist and he spit on her. She was holding her 1-year-old daughter at the time that this incident occurred. And that is the preceding incident that happened in 2021. And then we have this next incident in 2022. For the same reasons that I outlined, the risk of reoffending, the danger to the victim, based on the violent criminal history, the multiple attacks on the same victim, and the attacks occurring in the presence of children. Our recommendation on the 2021 case, the simple battery is a $5,000 surety bond, no further contact with the victim, stay away from the incident location, 1-day anger awareness, no alcohol, drugs, or weapons, and a third-party transfer for children. And that's the state's position in this case. Thank you, Your Honor.
Thank you, Ms. Gant.
Your Honor, I do not represent the client. However, Ms. Kim advised me that she was knocked off the Zoom call, so I just sent her the link, so she should be signing back on momentarily.
I see her.
Okay.
Yana, I know the.
Hold on, Mr. Scott. You have a right to remain silent. Anything you say can be used against you. I don't want you saying anything until your lawyer appears back with us, sir, okay? So just sit tight for me. We have one left, or courtroom 2. How many do we have left today?
Just one left.
And that's Mr. Toes. Towers?
Those is reset.
Oh, he's reset?
Yeah, we got Rashard Williams. That's the only file I have left.
Yeah.
And who's representing Mr. Williams?
Your Honor, J. Kim.
Oh, that's Ms. Kim also? Okay. I was gonna go to Mr. Williams, but since we're still waiting for Ms. Kim to log back on.
Okay.
Ms. Gant, you there?
Your Honor, I am giving her the meeting ID and passcode. She states that her internet died, so she is trying to join from her phone.
Okay, very good, thank you.
You're welcome.
Okay, while we're waiting on Ms. Kim to join us, we'll go over the calendar since we only have 2 cases left.
Anybody hear me?
Yes.
Thank you.
Position one, I'm sorry, the SAP reset date is May the 10th. Position one is a $1,000 surety bond, reset SAP. Position two is a $500 surety bond, reset SAP. Position three is a $2,000 sign-on bond jail. Position four is a $500 surety bond, reset SAP. Position five is a $500 surety bond, reset SAP. Position six is a $5,000 sign-on bond jail. Position seven is reset to tomorrow's SCA 426. Position eight is a $2,000 sign-on bond jail. Position nine is a $2,000 sign-on bond jail. Position 10 is a $1,000 surety, reset SAP. Position 11 is a $3,000 sign-on bond jail. Position 14 is reset to the 426.22 SCA. Position 15 is a $3,000 sign-on bond pretrial. Position 16 is a $3,000 sign-on bond pretrial. And that's it. And Ms. Kim is back.
All right. Ms. Kim, we had, I don't know where you left us. We've completed the solicitor's recommendations. So are you ready to proceed? Okay, I can't hear her. Can anybody else hear her?
I can't hear nothing.
Can't hear you.
I can't hear you, Ms. Kim. Okay. Say it again.
Can you hear me, Your Honor?
Okay, now we can hear you. Okay, thank you. You can go ahead.
Thank you. I apologize. Mr. Scott is recommended for unsecured judicial relief, signature on bond, and he has been here in Georgia for 13 months, and he has a child who is 1 year old, and he has a job. He has been working there, gainfully employed for about a year, and he also has a degree, bachelor's degree from online school for waste management, and he does not have any other recent violations. So we would like to request for signature bond, Your Honor.
I don't have that he's recommended.
Yeah, I think that bond order was a typo.
Oh, okay. And yet, we still would like to request for signature bond, Your Honor.
Okay. Ms. Clark, I see you there. If you would like to address the court, you'll have to unmute yourself and I'll have to swear you in. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you, ma'am. You can put your hand down. What would you like to tell the court?
Okay, so firstly, I believe that the police officers that came out may have made a mistake with what they were hearing. The very first incident, which has only been 2 incidents in general, which are what they stated. The first incident, it was just the spit and the choke. The second incident, it was just the hit. There has not been multiple incidences where we have been getting into it or anything like that. He's a great dad. I'm not gonna stay away from him, not to say it like that, but he's a great dad and he's not a bad person. We've been together for 5 years. So I most definitely, I don't think that the incidents are gonna continue. Yeah, other than that, it's not really much I can say about him. We had our ups and downs and it was just 2 incidents.
Okay, let me just say, if I have to call the police because I can't handle something, it's a big deal, okay? Because it is, and it's never just a spit and just a choke. If somebody spit on you and choked you, and you call the police, that's significant, especially if they did that in front of your children, okay? And then there's a second incident of where you had to, that apparently where you had to call the police again, that again, happened in front of your children, and you could not, handle the situation, on your own. I understand that, but I can't, keep returning someone to a household where there is some type of allegations of violence where you yourself have had to call the police. You understand what I'm saying? So, and I've heard nothing about in the interim between the first time you called the police and the second time that, any help was given or there's been any type of, intervention, to help you and your children. So you understand what I'm saying, Ms. Clark?
Absolutely. May I speak?
Yes, go ahead. Go ahead.
Okay. What I was just gonna say was, like I said, it hasn't been multiple incidences. Yes, it did occur when my daughter was around. But you had stated, I'm sorry, it was something you had stated that I wanted to touch bases on, but I really don't recall at the moment. But all I really wanted was for him to leave. It wasn't, anything other than I wanted him to leave.
Okay. And you live at the 42, what's it, Raywan Street?
No, it's Rawson. It's Rawson, Rawson.
Okay. And you live at that address with your children?
I just have one child. We both have one child together. And yes, we both live there.
Okay. And okay. Anything else, ma'am?
No, sir. I don't think he's a bad person. I just think, he might need a little guidance.
Okay. Ms. Harmon?
Yes, Your Honor. I would just have to kind of state that 2 incidents does qualify as multiple incidences from our perspective, and it's concerning that this all occurred in less than a year. The victim just stated that the defendant choked her, which we would call a strangulation. and spit on her in one incident. And in the next incident, it was visible bodily harm. So that feels like an escalation to me, Your Honor, with busted lips, scratches, and all of this is recorded on body worn camera. I would have to strongly stay consistent with my recommendations, respectfully with what the victim has testified to. Respectfully, I believe that no further contact is absolutely necessary. I absolutely believe that the surety bonds in this case are warranted. And I absolutely believe that he definitely needs the intervention of the anger awareness along with the other conditions, no alcohol, drugs, or weapons, in this case for the victim's safety and for her daughter's safety.
Ms. Kim, I would like to talk.
Mr.
I would like
Scott,
to
I
make-
strongly recommend you not to advise you not to speak because
I would
it
just like to
can
say
be used
one-
against you.
No, I
Only
understand.
about the bond, sure.
I would like to just speak to the judge, if you don't mind. Judge, I'm stepping on what you were saying about it was no further. I took the initiation to myself because hands down, I understand, you know what I mean, I got upset. I took the initiation to go through anger management classes with myself. I did that. I also took the initiation to get my own place. I did that. I love my daughter. Even in the midst of us going through it, you can see I send whatever she needs, money, financially for the both of them. You're right, space is needed, totally. I never physically, I'm 6'3", 220 some pounds, Your Honor, full of steel. I never, you know what I mean, like physically choke her. I did, you know. I don't know, Your Honor.
Please stop talking about the case. I strongly advise you not to talk about your case or facts. Only about the bond, please.
So it's my understanding that from what Mr. Scott just said, that he does not live at the Rawson Street address.
Correct, Your Honor. That's
Okay.
the way I understood it too.
All right. So what I'm going to do is for the July 13th, position number 13, it's going to be $1,000 good bond. And I'm not going to keep you away from your child, Mr. Scott, but I am going to keep you away from Ms. Clark at the present time. All right, so it's no further contact with Ms. Clark. Stay away from the 42 Rawson Street address. You can see your child. There has to be third-party contact for you to see your child. If you have any belongings at that Rawson Street address, you can have a one-time escort to retrieve any belongings that you might have there. And no drugs, alcohol, or weapons while out on bond. For position number 12, the most recent allegations, it's going to be a $2,000 good bond. No further contact with Ms. Clark. Stay away from the Rawson Street address. Third-party transfer and a one-time escort, and no drugs, alcohol, or weapons while out on bond. So total for both cases will be a $3,000 good bond. All right.
Thank you, Your Honor.
All right, good luck to you, Mr. Scott, and you also, Ms. Clark.
Next, we have position 17, Mr. Williams. Okay, you're done.
Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes,
Thank you.
How you doing today?
I'm doing well. Thank you, Mr. Williams. You've been charged in case 22 CR 002452Y with simple battery family violence. Is there a history, Mr. Howard?
I got first arrest.
Ms. Harmon?
Yes, Your Honor. The offense date was April 23rd, 2022 at the location of 131 Ponce de Leon Avenue Northeast in Atlanta, apartment 507. It appears that the officers were dispatched to that location on a fight call. The parties lived together at the incident location, and the victim in this case is Marlon Smith, common spelling for both names. They got into a verbal argument about the defendant taking too long to come back to the house, which escalated into a physical argument where the defendant punched Mr. Smith and pushed him onto the ground. So it appears that the victim in this case did defend himself by hitting him back, but he did not he was not deemed to be the aggressor. We believe that this defendant presents a danger to the victim based on the incident details. And basically because he is the one who initiated violence, our office did get to speak with Mr. Marlon Smith, and he said that they have been on a living together for the last 2 years. And it seems that this has been the first time that it's become a physical confrontation, and that was initiated by the defendant, which is concerning. Because if they were living together peaceably and the defendant just initiates violence, that's concerning to us. In light of the following, in light of his limited criminal history, but taking into account the danger he does present to this victim, our recommendation in this case is a $2,500 surety bond, no further contact with the victim, Marlon Smith, stay away from the incident location, a one-day anger awareness course, no alcohol, drugs, or weapons.
Ms. Kim?
Yes, Your Honor. Mr. Richard Williams is 33 years old, and he has been here in Georgia ever since 2019. He does not have any families except significant other, Mr. Smith, Marlon, who they reside together. And he is currently employed. He has been gainfully employed for the last 2.5 to 3 years. And he graduated from high school and college from Tennessee. He has a bachelor's degree. He does not have any other histories as this one is not a typo. He is qualified and recommended for signature on bond. So we would like to request for signature on bond. And also, I do not think Mr. Marlon is scared of him anymore. So we would like to request for no further violent contact. Thank you, Your Honor.
Mr. Smith, I see you on the line. If you would like to address the court, now is your opportunity to do so. You don't have to address the court, but if you would like to, you'll have to unmute yourself and I'll have to swear you in, okay?
I'm unmuted. Hello, how are you?
I'm doing well, thank you. Can you raise your right hand for me, Mr. Smith? Do you swear affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell the court?
The incident, it definitely was no punches. It was a snatching of the cover, and once I felt like I need to get up, that's why I kind of got him off of me, and he just pushed me back and I fell. It wasn't anything more.
May we
say that again?
May we limit to the answer as whether he's still afraid of Mr. Williams or not?
I was never afraid of him. He's not a violent guy at all. So
thank you.
Yeah.
All right. Anything further, Mr. Smith?
Yeah, I mean, that's it. He's not a violent guy. It's just a misunderstanding, and we didn't handle things the way by just simply walking away from it that time. And that's how we usually do and revisit things. So no, there's no issue at all with him. No.
Okay. It's going to be a $3,000 signature bond through pretrial, one-day anger awareness class, no further violent contact with Mr. Smith, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr.
Thank you.
You also.
Thank you so much.
Okay, courtroom 2. Is that, you're welcome. Does that complete everyone, courtroom 2?
Yes, we're done. Thank you,
All right.
Judge.
Thank you. We'll see you tomorrow.
All right, have a good one. Thanks.
You just do the same. Be safe. And we've already gone over the calendar. Does anyone else have anything more for this calendar this afternoon?
No, Your Honor.
Okay. If not, I will see you all tomorrow.
Thank you very much.
All right. Y'all be safe.
Bye-bye. Thank you for your patience. Bye-bye.